Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, but as uncertified podcast hosts, we try to bring our audience of trial and appellate attorneys some legal news and perspectives they can use in their practice. As always, please recommend this podcast to a colleague if you find it helpful.
And before we jump into this week's discussion, we want to thank Casetext for sponsoring our podcast. Casetext is a legal technology company that has developed AI-backed tools to help lawyers practice more efficiently since 2013. Casetext is relied on by 10,000 firms nationwide, from solo practitioners to AmLaw 200 firms and in-house legal departments. In March 2023, Casetext launched CoCounsel, the world's first AI legal assistant. CoCounsel produces results lawyers can rely on for professional use, all while maintaining security and privacy. Listeners of the podcast enjoy a special discount on Casetext basic research at casetext.com/calp. That's casetext.com/CALP.
All right, Jeff. So this is the episode. You've finally done it. You've brought on Jack Metzler to the podcast today. Now, Jack is an appellate attorney at the District of Columbia Office of Disciplinary Counsel, where he's a senior assistant disciplinary counsel. But our audience of legal and appellate nerds know Jack as the proprietor, the originator of the cleaned up parenthetical. Before that, or maybe in parallel with that, Jack is also the author of Posner Thoughts, annotated and expanded version of Jack Posner's of Richard Posner's anonymous fake Twitter account called Posner Thoughts, which purports to tweet Judge Posner's thoughts within Twitter's.
Tim, I'm sorry to interrupt you, but it's Posner. I can't. You're hurting my ears.
the nerdery already begins. Jack, keep calling Jack. Judge Posner's thoughts within Twitter's 140 character limit. Judge Posner himself admits to reading the account with great enjoyment, finding it extremely funny. Some examples of Posner's thoughts. My preschool was highly regarded, and even more so once I entered. I never graduated from high school. Didn't need to. I went to Harvard Law School because Yale seemed too easy. And back then, a Supreme Court clerkship was no real biggie. Among Jack's other risky ventures, as I mentioned, he holds the credit or blame for proposing in 2017 the use of the parenthetical cleaned up after citations to cases in quotes that have been cleaned up, or as I'll argue, bowdlerized. Since then, well over 5,000 opinions from many courts, including federal and state appellate and trial courts, have adopted Jack's cleaned up parenthetical. Just a bit of the origin of cleaned up. Jack had published an essay in the Journal of Appellate Practice and Process on the parenthetical cleaned up citations some years ago. Apparently, Brian Garner has endorsed the practice, and the most prominent cleaned up user is Supreme Court Justice Clarence Thomas, who included it in a February opinion. Was that February last year, 2022, Jeff or Jack?
I think that's right.
And according to information that Jack gave the ABA Journal in March 2021, the cleaned up parenthetical has appeared, as I said, in over 5,000 judicial opinions. Well, Jack Metzler, welcome, I think, to the podcast.
Thank you. Glad to be here.
Glad to have you, Jack.
Yeah. Be on your guard. You've got one super fan and one doubter, Jack, here. So let me ask you to get started here. When you're not busy needling federal appellate judges and the driving conversations of legal and appellate nerds everywhere, I assume you're doing some actual legal work somewhere. Tell us about your legal practice.
Sure. So I have, since the beginning of the year, I'm the senior assistant disciplinary counsel for appellate litigation for the DC Office of Disciplinary Counsel, which is in our system, the prosecutor of attorney discipline cases. So we've got people who prosecute those before hearing committees, and there are two levels of appeal before our Board of Professional Responsibility and the DC Court of Appeals, and I am in charge of our appellate section.
Okay, and in what appellate courts are you most typically appearing?
So now I'm exclusively in the DC Court of Appeals. Before I had this job, I was at the Federal Trade Commission, where I did appeals in all of the regional courts of appeals and the Supreme Court. Well, I shouldn't say all. I didn't get to all of them, but a lot of them.
Now, does the DC Courts of Appeals embrace the use of cleaned up?
Yes. Well, along with every federal court of appeal, about half the state highest courts of appeals, and I think all or maybe all but one U.S. district courts have used it. One judge or that. Not every single judge, but almost. But every court. There may still be one outlier. I didn't check today.
Okay. We always like to ask if you got an interesting war story or a mistake that you've seen opposing counsel make that has stayed with you over the years, something that you like to, or maybe if you were mentoring a young lawyer, something you'd like to pass on and say, make sure whatever you do, don't do X.
Well, boy, that's tough to do that within the most recent things to think of are things I shouldn't talk about because they are ongoing.
Yeah.
Let me put a pin in that. See if I can give you.
Yeah, we can bookmark that. Mine is don't ever use the parenthetical cleaned up, but our mileage may vary on that.
Come on, Tim, that's going too far.
All right. Well, let's get right into it. I mean, I think when we post this episode, Jeff, we're going to have to put a prominent nerd alert on it because if you are aware of the parenthetical cleaned up, then this is going to be of great interest to you. If you've never heard of it, then maybe just go on living your life. But I wanted to give a quick origin story, or maybe Jack, would you like to give the origin story? I thought maybe you've given so many of these podcasts that you were tired of it by now, but I was interested to learn that you have not been sought out by so many other appellate nerds like Jeff and me to talk about the origin story of Cleaned Up. Would you kind of give us a rough overview of how it originated?
Sure. So it was 2017, and in the spring, it was March. And as I recall, it was late at night and I was reading on my phone. It
was getting very literary. Was it a balmy day?
Yeah. It was a dark, not stormy night. But anyway, I was reading on my phone a decision that had come out that day. And it was one that people had been talking about on Twitter. And if I think it was one of the immigrant, it might have been like the DACA case or one of those, that it had come out from either like a district court in Texas. And as I was reading along, I came to this section where I recognized this problem. The author, the judge, was quoting cases from that had been quoted before many times, and you could just see in the writing the struggle that he was having with all of this extraneous brackets, and sometimes there was like an emphasis that had to be removed or an emphasis that was added, and it had to be like the second case back had added an ellipsis or something like that.
All those lovely square brackets everywhere.
Right. And so I recognize this problem deep in my soul from encountering it many times myself. And I was like, you know what? I know what this judge is going through. And why do we even bother with any of this? The thing is, if you're going to quote a case and you're going to quote a case because the court said it, now the court quoted something else, fine. But judges don't. Like you never say the holding of a case is we hold that, bracket, lowercase a, LL, men are created equal,
Imagine if we had to talk like that.
Right. So that's not the holding. When the court holds something, it holds like the words, not the extra stuff. And so, if that's the purpose, I thought, then why do we have to do all that? And I'll be honest with you, because this is a topic I think that people think about most of all when it comes to Cleaned Up, is they think that this is the biggest objection. It sounds too colloquial. And I spent a good 90 seconds thinking about what would be the best phrase to use. And I rejected some things, I came up with some others, and I just said, I think cleaned up pretty much does it. And so then it was late at night, but nevertheless, there was a good response on Twitter, like an enthusiastic response on Twitter, I would say. And so like within the next day or two, I wrote up, I sort of fleshed the idea out into a couple of pages, and then later turned it into the article, which eventually was published.
All right. So we got the origin story of Cleaned Up is 90 seconds of deep thought followed by an enthusiastic response on Twitter.
Right.
All right. And then just for our audience who maybe is not aware, hasn't come across this thing, this cleaned up parenthetical, what it does basically is, as Jack mentioned, when you've got a quote that you want to use in a case, but it's got a lot of these ungainly special characters, square brackets and ellipses and things, and it's not really germane to the quote that you want the court to read, you just strip all that out. And then when you cite the case, at the end of the case, you put a parenthetical that says cleaned up. And the purpose is to allow the author to remove non-substantive material like brackets, ellipses, quotation marks, footnote call numbers, and internal citations, or to change a letter's case without placing the changed letter in brackets, and to omit any reference to an intermediate decision in a chain of at least 3 decisions, like when quoting a decision that quotes a second decision, that quotes a third decision, this recursive nightmare that sometimes happen. You can just omit reference to the second decision, and then just follow it up with a cleaned up. And if the judge is, if your reader is curious, that cleaned up citation parenthetical lets them know, okay, well, if I want to explore further and see what exactly has been changed, I can go back to the author is at least telling me that something has changed. So if I find anything fishy, I'll just go check the work.
Exactly right. I mean, and the analogy, the best analogy is, the ellipsis. We don't tell people, no style guide tells you what you're supposed to, what you are allowed to and not allowed to leave out when you have an ellipsis. You're just, relying on the court to trust you, or if not trust, then to verify. They can always go and see what you left out. And I think actually, if you want to go back, that's one I've seen before. To your original question, do not, young attorneys, ever do something like use an ellipses to take out the word not. That's a bad idea. And although I haven't seen that one exactly, I have seen some unscrupulous uses of an ellipsis, and I would not recommend that. I would recommend against it.
What about the use of cleaned up to change to substitute a party name with the party designation? Like instead of using Smith, take out Smith and replace it with plaintiff. Would that be an acceptable use of cleaned up?
No.
No.
Any change to any words is not allowed. So the idea, like I said before, is if and I should also say this is only for courts, for quoting a court. It's not for statutes or books or articles or anything else. And because the justification is when you're quoting a court, you care what the court said. You don't care about, honestly, it doesn't even matter that the court quoted someone else, because ideally that's the court that, the court that you're quoting is the one you care about. If the Third Circuit said it, well, maybe the Fourth Circuit said it first, but you're in the Third Circuit and you want the Third Circuit to know that they said it. So it doesn't really matter that there's no obligation to tell the court that the Fourth Circuit had the idea first, for example.
Yeah, no, that makes sense. When you put it that way, that it's when you were talking, I imagined, what if the judge who authored the opinion was reading the opinion from the bench, as for example, the Supreme Court justices will sometimes do, and when they read quotations, they're not going to indicate whether there's and then begin a single quotation and then close with a double quote. They're going to omit all that when they read it. And so when you are putting a quotation in your brief, maybe you just put the words in there. The syntax is not really important. You just transcribe it as if the judge had read it speaking, rather than in writing with all of the symbols.
Yeah, I think that's a pretty good analogy. I never thought of the speaking out loud, idea before.
Yeah, well, I mean, I'm reminded that the Old Testament scriptures or the Torah didn't have it didn't have chapter numbers or anything, and I don't think it had a lot of the apostrophes and other syntax. They just had the words, and a lot of that was not added until much later on. So maybe it's similar thinking there, that all of these special characters on our keyboard are really just flourishes that we add in the editorial process, and they could be edited away by a subsequent author without any substantive change.
Well, I can't speak as to that. I think don't change the periods or commas, at least not with cleaned up.
Okay, so you're a comma purist.
Well, that's part of the text. It's not when I say punctuation, I just mean brackets and the stuff that really doesn't change.
Yeah, well, that can set off and signal in clauses and things like that. So that's a good point. All right, so that's the story behind cleaned up. Can you tell us what's been some of the controversy behind it? You mentioned, obviously we've got well over 5,000 opinions that have used it. So judges, many judges obviously have felt comfortable using it, including the Supreme Court. At least we know Justice Thomas has felt comfortable using it in the Brownback decision. Do you know? Are you aware? When I asked you if courts are adopting it or embracing it, we could talk about how many courts are using it in their own opinions, but does that mean that the courts are inviting practitioners to use it? Is there a difference between a judge using the cleaned up parenthetical and an attorney practitioner using the cleaned up parenthetical in their briefs?
Well, so I think some judges, I think, and when I say some, I can think of two, have that view. And certainly I've heard it from some practitioners too, that, this is fine for judges, but not for attorneys. So, okay. But I really don't see any difference. Again, I go back to the ellipsis. If you allow, I shouldn't say trust, because there are good reasons not to trust attorneys. I work in, disciplinary cases. There are good reasons not to trust attorneys. But there's no rule against using an ellipsis. And really, nothing in the Blue Book prevents you from just using an ellipsis to take out the word not. That's on you. That's trusting you to do that. And, you could do it. You violated no stylistic or Blue Book rule, but you're going to get in some big trouble because you're misrepresenting things to the court. So I really don't see cleaned up is actually much different, because you're telling them things have been removed, and you're on your honor, not just to say that you haven't removed anything important that you decided, but that you actually haven't removed anything except brackets, ellipses, an internal quotation mark. Internal quotation marks, citations, or a footnote reference. So if they say that for attorneys, your reputation is your practice. That's the whole thing. And when judges start looking it up and seeing that you're not doing what you are implicitly promising to do, good results are not going to follow from that. So I don't really understand why people would say this is fine for judges, like we trust judges more than attorneys. Well, I've seen some judges, do some things in opinions that are that I would question. Let's put it that way.
Right.
Well, let me ask you this follow-up then. If you're quoting something in a brief and you're choosing not to paraphrase it, but to quote, to use the quote, because that quote is so good, it transcends being paraphrased. The court really needs to know this quote because it's so good, but it needs to be cleaned up a little bit. And if you're right that the quote is so good that the court's going to stand up and take notice and say, oh, this is a really good point. Oh, but it's cleaned up. You're going to send the judge back to check it out and see what's been cleaned up. Is that going to risk irking the judge a little bit that, well, this is a really good quote, but I'd rather just be able to see exactly where it came from, how it appeared at this citation that the attorney is pointing me to. Wouldn't the judge rather see the quote with all of its warts, all of its ungainly symbols, rather than have to go back and check the attorney's work to make sure that no substantive material has been cleaned up?
I see Jeff shaking his head.
Jeff
So
wants to
I
take this
just,
one.
I got to jump in here. My assumption is every time we file an appellate brief, is there some clerk or research attorney who checks scrupulously every citation of fact and every citation to law. They don't take Jeff Lewis's word for it. And what a great opportunity to build credibility with the judge or the law clerk or the research attorney than to have faithfully executed on cleaned up and provided a good cleanup of all the extraneous garbage. So that's where I land.
I mean, I have to agree. Sorry, Tim. When I clerked for Judge Choflat on the 11th Circuit Court of Appeals, and he would sometimes say, "What's rule number one?" And I'll tell you what rule number one was: we don't trust the lawyers.
Wow.
Maybe you can build up that trust over time, but as far as but I agree with Jeff. You're making it easier for the judge to read it because some clerk somewhere is going to go make sure that you haven't misrepresented anything, and the lack of hearing that when he doesn't hear, oh, those cleaned up sites, you really can't trust those. Not hearing those is going to build your credibility with the judge.
Okay. All right. Well, you survived that objection. Let me put to you another objection that I found from Professor Tessa Dysart. Here's what she wrote in a post. I'll link it in the show notes here. This was back in 2021. She said, perhaps one of the best explanations, she's talking about generally here, the role of citations. And then we'll get to the question about cleaned up, how it applies to cleaned up. One of the best explanations of the role of citations that I have read, and this is Professor Tessa Dysart, that I've read came from Eugene Volokh. Eugene Volokh wrote, I remember asking a federal appellate judge once why courts don't shift more to the citations in footnote style. That's another barbarism that Brian Gardner has endorsed along with cleaned up. I'm in jest a little bit here, but I've got to give some pizzazz to it. Why don't courts shift more to the citations in footnote style, which I had thought looked cleaner and made it easier to follow the flow of the argument? Same argument for cleaned up. And the judge laughed and said something like, you view citations to authority as support for the argument, but I view them as often the most important part of the argument, end quote. So here's back to Professor Dysart's commentary. If judges view citations and quotations to case law as the most important part of the argument, then they might want to be wary of efforts to clean those sources up. And one of the judge's most common complaints about briefs is that attorneys misstate the law in the record. As you pointed out, rule number one, we don't trust the attorneys. That post, in fact, Professor Dysart's referring to a previous post of hers where she had discussed a Ninth Circuit opinion where the court chastised attorneys for misrepresenting precedent by altering quotations from cases. So what's your response to that? Is that along the same lines that, well, you're not going to trust the attorneys anyway. You're always going to go back and check the sites. But I guess I'm still questioning, wouldn't it be better? Let me put it this way. Wouldn't it be better, instead of using cleaned up, which is, I think you mentioned one of the objections to it is too colloquial. The way I would put it is that all the other parentheticals we have are very precise about what the author has done. You know, internal quotation marks removed, internal brackets and alterations removed, internal ellipses and citations removed. You know exactly what the author has done. With cleaned up, as I mentioned earlier, it's understood that it just means the non-substantive material, but the words cleaned up by themselves don't contain that. You have to refer to that, that definition that is outside the four corners of the parenthetical. So is that a problem? Wouldn't it be better just to say, here's what I did in reporting this quote?
So a couple of things. I agree with Scalia and Garner have this discussion in their Making Your Case book, where Garner is of the idea that you should put citations and footnotes. because it's easier to read. And Scalia says, no, you want the judge to check your work as you're going along. And Alexa Chu, who's another legal scholar and sort of of citations, has an article called "Stylish Legal Citation," and in which she argues, and I very strongly agree, that the citation is part of the argument, and it goes like this, right? So if I say X proposition, right? That all you have from that is me. Jack said it. Well, who cares what I say? But if I follow that with a citation, then you know that that's not just me talking. That's the Supreme Court of the United States talking. And not only that, you get to find out some things. That was a case that was, let's go back a couple of years where it's not quite so questionable. Like that's a case from 2020. It's not that old. And you might find out that that's the Fifth Circuit. Well, I'm in the Fifth Circuit, or maybe I'm a district court in the Fifth Circuit. That's my boss who said that. So just through the citation, you get to make part of your argument. You build credibility every time. This is why I think inline citations are the way to go. So it's not just about, and I mean, sure, I agree with Garner. It would be easier to read. But if you're reading like a fiction book, that's swell. If you're reading an article in a magazine, great. But what you're doing in a brief to a court is trying to convince the court that they should do something because that's what the law is. And the law comes in our common law system from these prior judicial opinions. Now, when it comes to quoting a decision, that gives you an even better opportunity, because it's not just Jack says it, and it's not even just that Jack says that the Fifth Circuit or the Supreme Court says it. Here are the words that the court used. And so you don't even have to trust me. Those are the words. Now, you might say, but what about the cleaned up? As we've talked about before, so the cleaned up is my representation. This time, you do have to somewhat believe me, but it's easy enough to check that I haven't removed anything substantive. Now, it doesn't say it within the corners of the parenthetical. And a couple of times you've said, well, maybe our readers have never heard of cleaned up, and they don't know what this is all about. And to those readers, listeners, I'm not very concerned about them. A couple of years ago, I used to get that. And I would say, look, if you have not seen cleaned up, then you are not reading cases that come out from the courts of appeals. I can't tell you how often I just get a note from someone, this big case that just came out has a cleaned up, because they all do. And I'm exaggerating, but just a little bit. Like the next time there's a big case, not in the Supreme Court, but every other court of appeals or a big district court decision, just take a look and just search for cleaned up. You'll see it there. So at this point, it's not really a question about whether anyone has seen it or whether anyone knows what it is. The people who aren't familiar with it and haven't seen it, you don't need to worry about them because they're not reading cases anyway.
Right.
Well, yeah, let me push back a little bit on this, Jack. I'm a big fan of cleaned up and a big fan of yours. But let me share something with you I found really interesting. I was at an informal Zoom of research attorneys with the Second District
Court. Formal
Court.
Zoom?
An informal meaning. It wasn't a. It was a meeting of research of attorneys for the Second District Court of Appeal in California, which is Los Angeles. And when I say informal, it wasn't the official position of the court. They weren't speaking on behalf of it. It was more like a Q&A of peeves of research attorneys and things that bother research attorneys, so we know how not to piss them off when we prepare a writ. And I asked this group, there's like 5 or 6 of these research attorneys, do they favor or are they against the use of cleaned up? And nobody in that discussion knew what cleaned up was, at least in the among the research attorneys. I was flabbergasted. I thought I'd get either strong reaction for or against. None of them had heard of it. I was shocked.
This was, who was the audience again?
This is research attorneys who were on a panel, In the Second District Court of Appeal, California Court of Appeal. And these are the attorneys who, do some site checking and draft opinions and that kind of thing. And they weren't against it when it was explained, but they just hadn't heard of it. I was just shocked.
Well, so this gets into the one particular subject, which may be touchy with you guys. I know this is the California Appellate podcast, but California has some rules that sort of make it difficult for cleaned up. As far as I can tell, the California state rules, at least the style guide, the California style guide, as far as I can tell, may be the only authoritative source that is actually against cleaned up. Not expressly, but by sort of the other rules, I think, seem to preclude it.
Okay, hold on. I gotta get. I'm gonna take notes here for ammunition against Jeff. All right, lay it on me.
He said maybe. There was a lot of there was some hedging. Go ahead, Jack.
I mean, it suggests, for example, so this whole idea of putting parentheses around a citation. Well, that's kind of odd. I guess what I would say is there's several of them. There's a rule about quotations within quotations, which is section 4.22 of the California Style Manual, which is contrary. Now, I know, and everybody knows that cleaned up is not in the blue book, right? So you're going against the blue book, full stop. But on the other hand, if the things that cleaned up replaces, which we all see a million times, not all of those are actually blue book standard either. So and I don't have this on the top of my head anymore, but essentially, if you are willing to say internal quotation marks omitted, brackets omitted, and so forth, you're already outside the blue book. So you might as well go all the way and just use an easier one. But see, and maybe you guys can tell me better than I know how much, my court doesn't have a style guide that I have to follow. Do you have to follow the California style guide, or is it just sort of optional?
It is optional. You can use either the blue book or the California Style Manual, but you are going to stick out like a sore thumb in the California state court system if you are using blue book rather than the yellow book, the California Style Manual.
Yeah. So that's that. In that case, I'm not really all that surprised that the people who are sort of very much in the weeds of checking the California citations are not seeing this, because they're probably going for mostly California cases, and there are California cases that use cleaned up. But I looked at them, and I'll be honest, it doesn't fit very well with the typical California style, just because you're already, just as a matter of, it's like automatically already putting in a bunch of extra brackets and parentheses. Like even like a second, if you string cite, you have to put the first one goes in parentheses, but if you want to have like a second one, that one goes in brackets. And also, like in a parenthetical, if you're quoting something inside a parenthetical and you want to sort of add your own little gloss at the beginning of the quotation, right? If you want to say holding that and then a quote, the holding that goes in brackets inside the parentheses. Am I right about this?
Yeah, I think you are. But let me also say the yellow manual, the yellow book has not been, I don't think it's been revised in over 2 decades. And
yeah, the version I have
is
like
my prediction that when it gets revised, cleaned up is going to be blessed in the next edition. That's my bold prediction.
Well, and Jack, you pointed out, you sent us a number of California state court published opinions that have used the cleaned up parenthetical. Jeff, you previously indicated that you'd only spotted it in one published opinion,
I thought it was one.
but Jack has found a couple of dozen. So
the reason I know about that one, by the way, Jack, is every time I submit an appellate brief, well, about say 90% of the time, I use cleaned up and I add a footnote citing to your article that kicked this off, and the one California case I was aware of that uses it as kind of authority for using the citation. So I'm trying to educate folks in California about it.
So I actually looked at that one, and I have to tell you, unfortunately, that is not the best example of the use of cleaned up.
All right. What
did
is?
the court misuse the parenthetical?
It didn't misuse it. It's more that it didn't use it enough. If that makes sense. So
that's the only sin that you cleaned up users only identify. Not
I don't know whether can I share a screen with you? Because it might make it easier.
Sure. Here, let me. I'll enable it here. See if I can, but we'll have to narrate. This is a there is a YouTube video version of the podcast, but most listeners are going to be listening only. So we'll have to narrate what we're seeing on the screen.
I want at least you to see it. So this is the on the left. I have the case that Jeff pointed me to, and you can see it uses cleaned up, and then the original case is on the right.
Yeah.
So I have highlighted here.
Oh, yeah.
What I think the court was doing on the right.
This is the original quote, the source of the quote.
Right. The original is on the right. And you can see in the original, it starts with a single quotation mark, then a double quotation mark. I'm sorry, the original.
Yeah, when you get a single and then a double quotation mark, you already know that you're already spotting a cleaned up use.
And then right after that, there is a T in brackets, and if you move on, you see there's an ellipsis, and then at the end of the sentence, there is in brackets
period, and then citation in brackets, double quotes, citations in another set of brackets, and then a single quote, and then a citation. It's just a mess.
Right. So what I think the court has done, if we go back to the right where they used cleaned up, is to get rid of all of that sort of that stuff that is highlighted, the citation in bracket, citations in bracket, an actual citation, and then some of these extra quotation marks.
Yeah.
But if you look what the court left,
it still left the unsightly square brackets at the beginning,
right,
and then the stupid ellipses in the middle of the quote.
Right. So the reason I say that this is not the best use of cleaned up is that it's
not a comprehensive use.
Right. So leaving that ellipsis in there makes this sort of confusing, because the normal use of cleaned up, you would take out an ellipsis, but you indicate your own changes in the normal way. So this suggests that the court that used cleaned up took something out between the word review and is, where that ellipsis appears. But in fact, it is quoting that ellipsis. So it's sort of like a backwards implication that ellipsis is the new court's work as opposed to something it quoted. I see why it wanted to get rid of the other stuff, but really what the court should have done here is just go all the way. I don't really care about the about changing the case of the first letter in the word the at the beginning, but that ellipsis is kind of problematic. So that's all I wanted to.
I also noticed that the in that parenthetical there, right before the before the parenthetical cleaned up is actually not even in a parenthesis in a parenthetical. The quote ends with a comma rather than a full stop period as it did in the original quote. It's a comma, close quote, and then the words cleaned up. That seemed a little bizarre.
So Jeff, you might want to look at one of those other examples.
Yeah, I will. But Tim, we just had on the screen an incomplete use of cleaned up on the left, and then a wordy, bogged down version on the right that had not been cleaned up. Would you not concede that the version on the left, which is much easier on the eyes, much easier to get your point across than the one on the right with all that bogged down citation and the word citation and citation right after each other?
Yeah, I'm not going to go on any ideological crusades against the use of cleaned up, but I'm still not sure that I'm going to use it. But I am much closer to being there than I was before we started this conversation. But one other objection that I've got. This is we're gonna pull the camera back a little bit. Are we are we making too much use of quotations? I mean, that quotation we just read was not such a sparkling and concise and pithy quotation that it could not possibly have been said in other words. Or why do we even need quotations? Just put what the court said. You can leave the quotation marks off. It's still what they said. Just put it. If the court, if it's not exactly what the court said, it's what you say it said. And obviously, as Jack pointed out, it's the words that are important, not the symbology that goes along with it.
Well, hey, hang on. Jack said rule number one is we don't trust the lawyers. When you quote a case, it's like there's a sub rule of, well, if they're quoting a case, maybe they're not so much lying this time.
Well, do you ever try to construct an entire brief out of just using case citations? Like, oh, that way you could never gainsay anything I said because it's all in quotations. It doesn't work that way. No. You have to put it in prose that flows naturally. And as we said, we don't trust the attorneys. We're always going to have to go back and check the sites, but hopefully you're proceeding brick by brick and making uncontroversial statements all along the way. They don't always have to be in quotation marks. Are we too addicted to quotations that we're creating these new innovations so that we can use them more without the unsightliness of all the extra symbols inside them?
Well, there's always the danger of this is why we can't have nice things. I think there's a balance, and it is certainly when you quote reflexively. I don't really think. I think we need to, attorneys as writers, we need to check ourselves on that. And there are times when it matters, in the heart of your argument, when you really do want the extra push that the authority gives you as you're going along, of course, subject to the original author's writing style and making it fit. It's very inconvenient when judges write things that are hard to fit into my sentences. But in those places, I think there's a good reason to use the court's words. But there are a lot of places where it's not. One of my pet peeves is when people will quote something where the context, clearly the court was talking about that case. Like, it's like, where the court says something like, and that behavior is outrageous and must be denounced. And people will say, just like in that case, the behavior is outrageous and must be denounced. Like, they're not comparing the actual behavior. They're just using that quote because it's, some words the court said that it wished that they could, that the court would say about their case.
Yeah.
And also in sort of less controversial parts of the brief where, if you say, there, in order to grant a motion to dismiss, there should be no genuine issue of fact or law, and the movement is entitled to relief. Well, you don't really have to quote Rule 12b-6 to get that relief. Like, no one's just going to be like, nah, where you check that out from? You can cite the rule, but you don't really have to quote it. So, I mean, that's my view, but we just need to check ourselves. And this cleaned up does make it easier to quote, but ideally, it's used it's used to make things easier when the quote would have been there anyway.
Yeah. All right. Well, here's my final question. I won't speak for Jeff, but this is along the lines of what we talked about earlier. This is if a practitioner, someone listening to the podcast is thinking about, this sounds like a pretty good idea. I want to use cleaned up, but I'm still a little concerned. I know a lot of courts, a lot of judges are using it, but how do I know that I'm not going to be submitting my brief to that one judge, or one of that small cadre of judges who just really doesn't like it? You ever come across any reports that there are some judges who just don't like it? Or I know Jack, you and Jeff are true believers. You'll use it anywhere. But what about those who are a little bit more trepidatious about using it? Would you caution against using it in any certain jurisdictions?
There's one place I would not use it and that it's because there's an intermediate court, I think in Missouri or Alabama, where two members of a panel went out of their way to say the very thing you suggested earlier, which is that this is fine for judges. We don't think advocates should use it. So if it were me, I probably wouldn't use it there.
Yeah.
On the other hand, other judges of that same court have used it. So, maybe they're gonna come around. There have also been an intermediate court in, I want to say Missouri. No, anyway, somewhere in the Midwest, or it's Colorado. I'm not very good with geography. Where initially at the beginning they came up with their own version of cleaned up. I think with the colloquial objection, like it was just a different couple of words, and there seemed to be sort of a little bit of tension on that Court of Appeals until their Supreme Court used cleaned up, and so I think that one's settled. So other than those two, I don't really think there's any place I wouldn't use it.
All right.
Okay.
And it's okay to use the emoji broom and an up arrow instead of the words cleaned up.
Sure.
Is that okay?
Yeah, that's fine.
Well, you'll go along with anything. All right. Well, I think, Jack, I think the record against you already is pretty damning at this point. But Jeff's going to conduct a lightning round to check for any other typographical barbarisms.
Nope. Before we get to lightning round, I want to ask you both about a kind of ripped from the headlines moment that's making its way through Twitter. I want to ask your thoughts on this. It's a practice I haven't seen here in California. I'm going to share my screen for a second. As you know, the internet is talking about this lawyer that's facing sanctions for using ChatGPT in a brief, and he's been ordered to show cause, and one of his lawyers asked for an extension. And this is the first time in 26 years practicing I've seen something like this. The district judge overseeing this issue denied in part, granted in part the extension, and did a handwritten order on the lawyer's letter requesting more time to brief or respond to this OSC race sanction. So my question is, Jack, is this common where you practice to have judges handwriting orders like this?
No, it is not.
As an appellate lawyer, it kind of gives me the heebie-jeebies of like,
I have seen, as an appellate guy, I don't do as much work in the district courts or trial courts generally. I have seen cases in which where courts require people to have a proposed order, and of course there's handwritten changes on that, and then sometimes they'll write in something that is completely that is just completely different, like no opposition. I've seen that before, which is relevant and a reason you might grant in addition to whatever the reasons given by the movement. But no, I haven't seen the full sort of let's just do it right now and file that.
Wow. Yeah. It's crazy.
Yeah, for the audience's benefit.
I'm pretty sure though, ChatGPT did not write that response.
That's right. Maybe that's the point to be made. And what we were looking at for the audience who's just listening is that we're looking at the lawyer's letter sent to the judge, and on the whole right hand side of it, in filling in all the white space, the judge had written the order denying the motion, just in handwritten. So yeah, that's a good point. You can be sure that that was not the product of ChatGPT.
And Jack, I don't want you to put in jeopardy any pending prosecutions or open cases, but do you have any thoughts about that ChatGPT and a lawyer's use of ChatGPT in briefs?
So, speaking in an unofficial capacity, I could tell you that in DC, the Office of Disciplinary Counsel is authorized to start cases basically if the disciplinary counsel learns about misconduct in any way. So if we read about it on the news or it turns up on Twitter, that is a fine source which could result in an investigation. And I'll tell you that the people involved in that case are not DC lawyers.
Well, okay. All right. All right, Jack. Well, to earn a podcast mug as a guest, you have to survive the dreaded lightning round, which is our patented copyrighted segment of the show that answers the most pressing questions that vex appellate nerds around the world.
Okay.
Short responses, one word or one sentence where you can, in the spirit of cleaned up. For your appellate briefs that you file these days, font preference, Century Schoolbook, Garamond, or something else?
Lately, I use Times New Roman.
And is that preferred by that court, or are you just a monster?
No. Do you want the full answer?
Yeah.
Yeah, let's do it.
So if you're filing a brief in 14-point Times New Roman double space, it doesn't make any difference, right? It's not any more or less legible than Century Expanded is actually my preferred font. And so Times New Roman is familiar. The reason people hate it is because it was the default font for Microsoft Word for so long. Now the default font is Calibri. If you file a brief in Calibri, you are a monster. But Times New Roman is fine. Garamond sucks.
Wow,
Garamond
shots
Ford.
fired.
Yeah.
Okay.
Well, my mind's blown here. I thought you were a trendsetter, and now you're like you're going back to a previous trend, and that's and you've got a valid reason for it. So I don't know what to say.
His reason's supported by authority. All right. I'm almost afraid to ask, but I'm going to ask the next question. 2 spaces or 1 after a period?
1.
Oh, fantastic. All right. Pled or pleaded?
Pleaded.
All right. When you're doing your major arguments, not the page headings, but the major arguments in appellate brief, all caps, initial caps, or sentence caps?
Initial caps.
Nicely done.
Did you say initial caps?
I'm sorry, wait. Small caps.
All caps, initial caps, or
Wait,
sentence
what are we talking about? Major headings like
major headings? Yeah.
Well, like introduction, summary of argument, that kind of thing.
No. Under that, like Roman numeral 1, the anti-slap motion should have been granted.
Roman 1, small caps.
Small caps. Okay. And final question, left justify or full justify for your briefs?
So I prefer left. The court that I currently practice before the most does everything justified.
Oh, okay. I guess they're justified in doing that.
Yeah. All
right, Jack, you earned your podcast mug and you survived our dreaded lightning round. Congratulations.
Thank you very much. This was fun.
Yeah, it was.
Let me give you one more thing because it didn't come up but I wanted to let you know in case you're interested. That article, Cleaning Up Quotations, Journal of Appellate Practice and Process, is the second most cited case in judicial opinions of all time.
Wow.
The most cited case is Brandeis and what's his name? Brandeis and Warren.
Brandeis briefs?
The right to privacy.
Oh.
And I should tell you, I'm only about 40 behind them, or 30. So
you're gonna overtake and be the most cited article of all time you said this is Supreme Court or all appellate briefs?
In judicial opinions, all state and federal. It's mostly due to a couple of judges who just keep citing the cleaned up article over and over again, but I'm still taking it.
Like it's stuck in some form template opinion that the judges keep reusing.
Right. Well, early on, a lot of people like you said, Jeff, you cite it every time. That's what reminded me of it. There's a couple of judges who still cite it every single time. And so, they've got 80 or 90 opinions that from the same judge citing it. But nevertheless, citation count, if you're just counting, I'm taking it.
Well, okay. Well deserved. Well deserved. I hope you get some sort of plaque for it at least.
I'll make up my own plaque.
Yeah. Cleaned up parenthetical somewhere on there. All right. Well, that's going to wrap up this episode. Again, we want to thank our sponsor, Casetext, for sponsoring the podcast. Each week when we include links to the cases we discuss, we use Casetext's daily updated database of case law, statutes, regulations, codes, and more. Listeners of the podcast will enjoy a special discount on Casetext basic research when they visit casetext.com/calp. That's casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@calpodcast.com. In our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right. Thanks again, Jack.
Thank you.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.